Cannot hear.
Hello.
Now can hear.
Yes.
Now can.
Is my sound clear?
Yes. Clear.
Unmute yourself, please.
Is anyone speaking there? Hello? Is anyone speaking there?
Hi, I
Sound actually.
they've muted all the microphones in the hall, but they haven't said so. So just be patient. I think they're trying to figure things out. Just be patient. This is Rama.
Today, we meet again. We resume the public inquiry. We're meeting today physically after a long lapse. Yeah. Of course, we had continued, but virtually. But today we meet up physically, and it's time for the oral submission. Mr. Simon, proceed.
Test. Morning, dear panel members, the observers from the Legal Council representing the family, PDRM, observers from Bar Council, observer from Contrast, colleagues from SUHAKAM. Good morning. It's Dr. Sri, the chair of the public inquiry into the disappearance of Joshua Hilmy and Ruth Sitepu. Mentioned just now that today is the day for the oral submission by all the parties. For your kind information, the parties have submitted the written submission to SUHAKAM on 17 January and by Bar Council yesterday. So we are here today to listen to the oral submission by the parties. And for the kind information, the SUHAKAM officers today, the secretary will not be making any submissions as we are involved in assisting the panel final report. But I'll be making some introduction remarks before we invite the parties to make the oral submission. And the order, we follow the normal sequence where we will invite the legal counsel of the family to make the submissions, followed by PDRM, Bar Council, and Contrast. So, just allow me to give some background to this public inquiry. Due to the serious concern surrounding 3 cases of disappearances, namely the disappearance of Joshua Hilmy and his spouse Ruth Sitepu, social activist Amri Chemat and Pastor Raymond Kong, on 20th April 2017, a coalition of civil society groups submitted a memorandum on behalf of the family members of the missing persons. SUHAKAM was called on to assist the families concerned to investigate and determine the whereabouts of the missing persons and to serve as a channel of communication between families, the police, and government of Malaysia. And on 21st April 2017, the chairman of SUHAKAM then, Tan Sri Razali Ismail, issued a press statement calling on the authorities to use all means at their disposal to discover the fate of these missing persons, to take all necessary steps to alleviate the concerns and unease among the public in this regard, and to bring justice to those responsible for their disappearances. And then up to June 2017, the disappearance of Joshua Hilmy, Ruth Sitepu, Amri Chemat, and Pastor Raymond Ko remain unresolved. On 16 June 2017, SUHAKAM released another statement stating that SUHAKAM will investigate the disappearances of missing persons in accordance to with its statutory mandate and powers as stipulated in Human Rights Commission Act of Human Rights Commission of Malaysia Act 1999. SUHAKAM further stated that it would assist the authorities with their ongoing investigations and call on individuals who may have relevant and important information to come forward to have their statement recorded by SUHAKAM. SUHAKAM then commenced the public inquiry into the disappearance of Pastor Raymond Ko on 19 October 2017, and the disappearance of Amri Chemat on 22nd January 2018. SUHAKAM had concluded its findings on the public inquiry into the disappearance of these two individuals, Pastor Raymond Koh and Amri Chemat, and the report of such findings were released to public on 3rd April 2019. However, due to the term of SUHAKAM commissioners, which came to end in April 2019, SUHAKAM was unable to continue the public inquiry into the disappearance of Joshua, Hilmy, and Ruth Sitepu. On 26 January 2020, SUHAKAM released a press statement to announce that SUHAKAM will be conducting a public inquiry into the disappearance of Joshua, Hilmy, and Ruth Sitepu. In its statement, SUHAKAM announced that the public inquiry is scheduled to commence on 18 February 2020. The term of reference of this inquiry was also announced. Just to refresh the memory of everyone, I will read the term of reference. A, to determine whether are the cases of enforced disappearance as defined under the International Convention for the Protection of All Persons from Enforced Disappearances, or are the cases of involuntary disappearances in breach or breaches of criminal and or civil and or applicable human rights law. B, if has been established at the inquiry, 1, how such alleged breach or breaches came about. 2, to identify persons or agencies responsible for such alleged breach or breaches. 3rd, to what administrative directive or procedures or arrangements contributed to such alleged breach or breaches. C, to consider whether the authorities, specifically the Royal Malaysian Police, have taken adequate steps to investigate such alleged breach or breaches. Finally, D, to recommend measures or guidelines to be taken to ensure that such alleged breach or breaches do not recur. So that was the term of reference, and this public inquiry was commenced on the 18 February 2022. That was the first date of the hearing, and the last date was 1st December 2021. In total, there were 22 days of hearing, or 22 sessions, and out of this, 14 sessions were held physical, face-to-face like this, and 8 sessions were organized via online. There were delays in the arrangements of this public inquiry, the hearing sessions, and such delay happened mainly due to the limitations during the COVID-19 pandemic, such as the movement restriction order by the government. Also, there were slowness in getting response from the other stakeholders because there were limited operations during the movement restriction orders. A total of 26 witnesses have appeared before the panel. Among the witnesses are the family members, friends of Joshua, Hilmy, and Sitepu, members from NGO, government agencies, enforcement agencies, and private institutions, including banks and telecommunication companies, have assisted in the public inquiry. In total, we have 24 open sessions and 2 closed sessions. There were also a few closed sessions among panels and other observers. The closed sessions were held due to the witnesses who have requested not to disclose their identity. After weighing the request, the panel agreed to allow limited numbers of closed sessions. And also there were also classified documents which were tendered during the hearings. And throughout the inquiry, there were 129 exhibits tendered in total. There were agencies that have assisted the public inquiry. I will read out the agency who have assisted the public inquiry. One is the Polis PDRM, Polis Diraja Malaysia, Jabatan Peguam Negara, Jabatan Pendaftaran Negara, Jabatan Immigration, Jabatan Ahli Islam Negeri Sembilan, Jabatan Agama Islam Selangor, Suruhanjaya Komunikasi Multimedia Malaysia, Malayan Banking Berhad, Maybank, OCBC Bank Malaysia Berhad, Bank Negara Malaysia, Maxis Telecommunications, U Mobile Telecommunications, GG Telecommunications, Yahoo Malaysia. And maybe I'll just take this opportunity to thank all these authorities and department and all witnesses who have lent their kind support for the purpose of this inquiry. So panel members, so that's the introduction, and just to give a background and to refresh our memory what happened because we started the inquiry in 2020. So that's all for me this morning, panel members. Thank you.
I will invite now counsel for the family of Ruth Sitepu to address the panel.
Honorable Commissioners of panel, let me introduce myself and my team. We are observers, counsels for the family of Sitepu family, Ruth Sitepu family. My name is Philip Koh. I'm accompanied by Miss Audrey Pillay and Mr. Cyrus Tew Fu Wei. Honorable Commissioners, for housekeeping, just a very humble request. The submissions that we will be making orally will be the highlighting of salient points. We will not burden the Commissioner with a verbatim reading of the text, but occasionally we may draw your attention to the written text for ease of reference. We have divided our labor in my opening statement, and the applicable law will be led by myself. Ms. Audrey will then proceed to look at certain evidential issues that would support our submission. And then Mr. Cyrus Tew, a very brief submission on the PDRM investigation and enforcement powers. We have also a very humble request that at the close of today, I may be given another additional 5 or 6 minutes where I undertake not to refer to anything by the other observers so that there is no protracted issue about a reply. I'm not replying to their submissions. It will be a closure where, with permission, I want to make a closing statement on behalf of the family. That's only for about a few minutes. I hope that will be acceptable to your good selves. Thank you, Dr. Suri. We'll be guided as we go along. Who is Joshua Hilmy?
I'm going to understand that you intend to present a video.
That will be towards the close, very short.
Close of your submission, yeah?
Close of the concluding statement. At the end of the day.
Can we request that it be at the close of your submission?
That means there will be no concluding statements by us, but we will do it. That means I have no concluding statement.
No, you can make a concluding statement.
But the video, we do it.
Yeah, at the close of your submission.
Thank you. We will do so.
Yeah.
Much appreciated by the guidance. That is totally acceptable, of course. We are guided by the rulings of the panel.
Yeah.
Who are the pastors of Joshua Hilmy and Ruth Sitepu? Joshua Hilmy is a citizen of Malay origin. His NRIC and birth name is Hilmy Hanim. Upon his conversion to Christian faith, he adopted a name called Joshua. Joshua means God is a deliverer. Pastor Ruth Sitepu is Rutanga Sitepu. He originated as an Indonesian from Nabiki, a small village in North Sumatra. She lived abroad in Malaysia to support her family. Upon completion of seminary studies, Pastor Ruth partnered Pastor Joshua in his work, and they both lived a simple life. On the night of 30th November 2016, they were last seen at their house in Kampong Tunku, Petaling Jaya. When they left their house, Pastor Joshua received prior to leaving the house, an unknown caller whom there was an agitated exchange. Since that fateful evening, upon leaving with their car, they were never to be seen nor heard again. One Peter Pomanan, a friend, made a police report on the 6th of March 2017. On 2018 February, Ruth family, led by siblings Iman Sitepu and Ram Elizabeth, flew in from Indonesia to make their requisite police report. Honorable members of the panel, there are similarities between the missing individuals of Pastor Raymond Koh and Amri Chekmak of Police Home. The disappearances of these individuals have a pattern, and we will refer to what is well known in legal circle, known as similar fact evidence, to establish this pattern. The Honorable Officer, Mr. Simon, has outlined the commencement of these hearings, and we will not repeat the same. Honorable panel members, what is the applicable law in relationship to enforce disappearance? It is a significant definition given to us under Article 2 of the International Convention for the Protection of All Persons from Enforced Disappearance. It has been defined as the deprivation of liberty by agents of the state or by persons or groups of persons acting with authorization, support, or acquiescence of the state, followed by a refusal to acknowledge the deprivation or a concealment of the fate or whereabouts of the disappeared persons, which places such person outside the protection of law. Honorable panel members, the Penal Code is clear that if anyone by force compels or by deceitful means, section 362, induces any person to go from any place, is said to abduct that person. Abduction, which deprive a person from the liberty of his or her movement, is a clear criminal offense, other than coupled with those sections on kidnapping and kidnap with the intent to even murder. Honorable panel members, acquiescence have also been defined, and in our submissions, we refer to a local decision as including a person who does nothing or next to nothing to a point where really there's an implied inducement with regard to infringing the human right or an assent to that infringement. The decision of the first panel of inquiry on Pastor Raymond Koh and Saudara Amri has given us the clarity of a precedent as to the applicable law and as to the receipt of evidence. It is clear that under the SUHAKAM Human Rights Commission Act, section 14, the states that the panel is not bound strictly by the provisions of the Evidence Act 1950 in the receipt of the evidence in such an inquiry of disappeared persons. We are also aware that the critical component in such an inquiry is the standard of proof, the issue of who bears that standard. We are aware even in civil law, the issue of res ipsa locita, my lord would understand that. There are knowledge that is only in the province of parties that they have that burden to discharge. Similarly, the first panel of inquiry have laid down that the burden of proof lies upon the state. It is the state that controls the means to clarify the facts that have occurred in its jurisdiction. The state has better possibilities of assuming the function of proving what it denies than the individual to prove what he affirms. In the Pastor Raymond Koh's final decision issued by the Honorable Commissioner Dato' Ma Wing Kwai, the Uruguayan case of Blair and Uruguay was held to be applicable. The committee, the inquiry of committee, may consider such allegations as substantiated in the absence of satisfactory evidence and explanations to the contrary submitted by the state party. And so the final decision of the Pastor Raymond Koh and Amri held that the panel is entitled to draw inferences which are submitted by observers on behalf of the then two families. We commend the same principle in this inquiry to your learned decision. The panel also observed that complainants do not have the means to identify with precision the state agents concerned in such disappearances. These are usually shrouded in circumstantial evidence, which give rise and can give rise to what is known as an irresistible conclusion that state agents are involved in the disappearance. Learned members of the panel, I shall now sit down and my learned friend, Ms. Audrey, will take us through in a short way the evidence, but I will also come in when on a part about the involvement of a wing of the PDRM. But I will take your injunction that we will then play the video before the concluding part of the submissions at this part, because I will still come in after Mr. Cyrus Chew have said his portion to round up part of the submission. Then we will play the video. Ms. Audrey Pillay, over to you.
Honorable Commissioners, SUHAKAM officers, fellow observers and members of the public. Allow me to just highlight some portions of the evidence based on our written submissions, and the evidential part will be on pages 11 through 27 of our written submissions. The first part of the evidential portion that we wish to highlight under paragraph D1 is the sensitive activities that this couple was involved in. It can be seen from all the evidence that was given in this inquiry that Pastor Joshua Hilmy and Ruth Sitepu, in their time of residing in the Kampung Tungku home, there were acts of kindness that they offered and showed to people when people were in need of temporary food and lodging, to even praying for people, especially when they faced difficulty, and giving them a place to just find rest and refuge. And this was regardless of race or religion. They also shared their faith with people who came to look for them for help and to stay with them. In fact, the evidence shows very clearly that inquiry witness number 16 and inquiry witness 18, Iqbal Mirza and Fazlina Amran, came to Pastor Joshua and Ruth's home seeking help when they actually faced difficulty with the supernatural elements, commonly known as black magic. And after they were prayed for, they were then baptized by Pastor Joshua and Ruth. And this was witnessed by IW5, Mr. Silva Kumar Harris. IW20, which is Reverend Dr. Herman Shastri, had given clear evidence on the rite of baptism, that it is undertaken when a person declares their intention to be a Christian, and it is administered, and then the individual is accepted into the community of faith. The baptism certificates were also shown on Ruth Sitepu's Facebook postings, and that is Exhibit 14A. And this indicates that this couple, IW 16 and 18, were baptized previously by Pastor Raymond Cole and then by Pastor Joshua and Ruth. These facts put this case squarely within the same category as Pastor Raymond Cole's. So the evidence is clear on the sensitivities of this case. Based on the clear evidence, and as my learned colleague, Mr. Philip Koh, informed the panel just now, we will be highlighting certain areas of the evidence. So based on the sensitivities of this case, it then brings us to paragraph D2 of our submissions, which talks about the prior threats and harassment that Pastor Joshua, Hilmy, and Ruth also received, which is also similar to the facts of Pastor Raymond Cole. This evidence of prior threats and harassment was given mainly by IW3, Josiah Nandan, and IW10, Susandi Basri, who personally overheard the loud, angry tones of Pastor Joshua Hilmy when he received phone calls. The first was in 2015, and this was overheard by IW3, Josiah Nandan, for himself. He heard these loud, angry tones, only one voice. He only heard Pastor Joshua Hilmy's voice. And after which, the couple left the home for about 2 months. And he told the panel that this was an unusual long absence that the couple had been away. Previously, they had gone and come back on shorter intervals, but this was the first time that they were away for such a long time. And IW3 was told personally by Pastor Joshua Hilmy that someone was disturbing them. And this resulted in them having to leave their home. Then we come to IW10, Susandi Basari. And he gave clear, undisputed evidence that he heard the agitated, loud voice of Pastor Joshua Hilmy on the very day they left their home, never to be seen or heard from again. And that is on the 30th of November, 2016. He said that he was seated in the kitchen with his sister-in-law when he heard this loud voice. So initially he thought that perhaps it was a married couple's argument, but he only heard one voice. To clarify his doubt, later on, he had a knock on his door. He was staying at the Kampong Tungku home with this couple when Pastor Joshua Hilmy knocked on the door. And Pastor Joshua Hilmy was fully dressed to go out. And he said to IW10, I received a call. And these are the exact words, in Susandi's own words. Dia cakap, bagi tahu saya, ada orang panggil, dah ada orang panggil saya pergi sahajalah. This is in lines 1 to 12 of page 148 of the notes of proceedings taken from Susandi's evidence. So Pastor Joshua Hilmy had told Susandi very clearly that someone had called, and as a direct result of that, they had to leave their home. And Susandi gave further evidence to say that, clarified that it was not a couple's argument. He overheard the casual, calm tones of both husband and wife as they stood outside at their car just before leaving. And he says this was approximately 10 o'clock at night. Therefore, it is clear and undisputed that both calls in 2015 as well as in 2016 was calls that were received and directly resulted in the couple leaving their home. On the first occasion for a period of 2 months, and on the second occasion, never to return to their homes. We submit that the contents of the call was sufficient to keep the couple out of their home. And that is why we are saying that both these calls were of a threat and harassment nature. paragraph 42, page 13 of our submissions, we also received further evidence that was given by IW5. And IW5, Mr. Silva Kumar Harris, told us very clearly that Pastor Joshua Hilmy had personally shown him emails that were received. And the words that we highlighted and we asked the witness was the email that said, "Jangan salahkan saya jika Anda ditahan oleh mereka." And then it concludes with saying, "Tapi pada pemikiran saya lebih suka pastor keluar dari Malaysia." These are the words that we wish to highlight. Ditahan, pastor keluar dari Malaysia. And this is said to a Malaysian citizen. Does this not amount to a threat and harassment? Because to us, this is clear deprivation of liberty of a Malaysian citizen. We go on to paragraph D3 in our written submissions. Numerous witnesses came and gave evidence on their own free will as to the fact of disappearance by the couple from 30th November 2016 onwards, and how this was very unlike their usual behavior, because they were very sociable people by what we have heard. They were in constant contact with people, either living in their home or constantly on Facebook. So they were very much social people. So all of these witnesses gave clear evidence that this couple has disappeared from 30th November 2016 onwards. This is what resulted in IW1, Mr. Peter Pembentangan, making the police report on the 6th of March 2017. And that is Exhibit 1 before the panel. Because unlike the previous occasions, this time the couple had been missing for more than 3 months. They never had contact with anyone at all. And by such time, news had already been made public about Pastor Raymond Koh's abduction. So knowing the similar sensitive activities that were undertaken by the couple, Pastor Joshua Hilmy and Ruth, Mr. Peter Pembentangan made the police report on the 6th of March 2017. So in summary, very quickly, we know for a fact that Pastor Joshua Hilmy and Ruth Sitepu did receive at least 2 phone calls, several emails. The first phone call in 2015 and the second in 2016. Those emails were allegedly from a cabinet member with letters bearing the official government logo. So the question then is, where, whom did these calls and emails come from? And that's the burning question in our hearts and in the hearts of the members of the public. To know the truth about the disappearance of this beloved couple. The question then arises, who was in a position to give the most amount of help in answering these burning questions? Where do we go to when we need the full machinery of investigations to be employed to find answers? Whom can we trust to give real help? As a Malaysian citizen myself, the first place that I would go to is PDRM. And to their credit, I have received help. On every occasion that I have been there, I have received help, and they have been kind, gracious, and generous. So what was the difference in this case? Paragraph 47 and 48 of our written submissions details a few things. If we could highlight, it was the SUHAKAM officers to undertake a thorough investigation pursuant to the SUHAKAM Act, to leave no stone unturned, to help and assist the panel in finding out the actual fact. One of the actual facts was when the telco officers came and told us that they retained 7 years of call logs, regardless of whether or not it is a prepaid or a postpaid number. And this was very different from the initial information that we first received from PDRM, where they said that it's only 3 months and postpaid you can trace, prepaid we can't. So the information that we received out of the efforts of the observers working together with the SUHAKAM officers was what produced helpful evidence in the inquiry. Paragraph 48.32 details that there was only one number that called Pastor Joshua Hilmy on the 30th of November 2016. And this number called 3 times on that day, once in the morning and twice at night. This number 016-5955720. The question then is, who had ownership of this number on the 30th of November 2016? Because it falls right smack spot on into IW10's evidence, the timing of the calls that were received, then followed by the couple's exit from their home at approximately 10 o'clock. So those calls fit right spot on into that time frame. The answer, unfortunately, is we don't know who had ownership of this number. And it shows clearly, the evidence shows that the number was terminated on the 19th of November 2016 and re-registered on the 28th April 2017, but under a different telco. So who could use the number between termination and re-registration? We don't have the answer. Which leads us to the question, who was in a position to be able to offer helpful evidence in answering that question? I reiterate what Mr. Philip Koh has said earlier, that the burden of proof lies squarely on the state. So it was the state agency to provide the panel with these helpful answers. In fact, if I could just remind the panel of what took place on the 1st of December 2021, that was the last hearing that we had before this panel. PDRM observers requested for more time to investigate when this piece of evidence came in on that final date. And Honorable Commissioner Gerald Joseph not only clarified with PDRM what exactly their request was about, and once that clarification was given, he proceeded to say that there is nothing that stops you from continuing your investigations, and whatever helpful evidence you get, please share that with SUHAKAM. To the best of our knowledge, as observer lawyers, we've not been given any further evidence. The Honorable Panel Chairman, in fact, remarked on that same day, shouldn't PDRM be the one forthcoming with this helpful evidence? But instead, it was the observer lawyers and SUHAKAM officers who had to ask the relevant questions and unearth helpful evidence. So we strongly submit that the state and its agencies have failed to discharge their burden of proof. Going on to paragraph D4, and that highlights what PDRM's efforts were in attempting to assist the panel in these investigations. Can we just say that none of the IOs who came ever came with their investigating diary or the investigation papers? And on this point, my learned colleague, Mr. Cyrus Chew, will highlight that portion. SUHAKAM had to push strenuously right from the beginning to ask for documents, initially met with a roadblock of AG's chambers will not disclose based on the fact that there are ongoing investigations. But after quoting provisions of the SUHAKAM Act, we then managed to get some evidence out. There were also unexplainable gaps. One major gap in PDRM's evidence and investigations was, and this question was actually asked by the panel chairman himself, who was the last person who saw Pastor Joshua Hilmy and Ruth Sitepu? And the answer that was given is, saya tak pasti, saya kena check IP. So who saw them leave? Who spoke last to Pastor Joshua Hilmy? That person was IW10, who gave evidence at this inquiry, Susandi Basari. Was he ever interviewed by PDRM? No. That is the answer, no. And this is his own evidence in line 12 to 23, page 173 of Susandi's notes of proceedings on the 1st of September, 2020. He said, no, I was not interviewed at all by PDRM. Then there were huge delays. Just to highlight the delay based on the most important witness, the two who overheard threatening conversations, IW3, Josiah Nandan. He came to this inquiry and said he was only interviewed by PDRM on the 11th of February, 2020, approximately 3 years after the police report was made and only 1 week before the SUHAKAM inquiry started. So that was when both him and his sister, IW2, Grace Tangamala, was interviewed by PDRM. Were there explanations on these gaps and delays? No. What about the emails? Because the threats and harassments are not only are in relation to the teleconversations, but also the emails. So we come then to the emails. IW22, Encik Zulkarnain bin Muhammad Yassin from MCMC. He gave various reasons, technical most of them, as to why they were not able to trace the origins of the email and the holder of that all-important email address, wifigirl@yahoo.com. But we also have no evidence from PDRM of them undertaking their own investigations within the establishment to send those emails to their own forensics department. When asked repeatedly about the contents of the email, IW14, ASP Zulfatli, refused to commit to an answer. We asked him repeatedly, does the content of these emails amount to a crime under the penal code if proved? And the words that the panel chairman used was, andai kata, if it is proven. Can these words amount to criminal intimidation under the penal code or any other relevant section under the penal code? And he just refused to commit to an answer. And the only words that we would keep hearing over and over again, biar kami siasat. That was the statement that we heard. When ASP Zulfatli, IW14, was asked why he chose to ask Maxis for call details for the month of October 2016, when the evidence shows clearly that the couple exited their home on the 30th of November 2016, and that was the last they were ever seen. So a reasonable, inquiring mind would think that you would need to go for the records, especially on the 30th of November 2016. So when ASP Zulfatli, IW14, was asked, why did you ask Maxis for the call records for October 2016? This was his answer. Random sahaja. Random. That was his answer to this inquiry. When IW14 was asked about investigations into the contents of the email, the named cabinet minister, the use of the Malaysian crest and logo, these were Exhibit 70 to A to D and Exhibit 76 A to I. He said he interviewed the relevant minister and that all knowledge of the couple and their activities was denied by the said minister. But yet, there were no investigations whatsoever by PDRM as to the abuse, the misuse of a cabinet minister's name and the abuse and misuse of a government logo. There was no evidence at all given on any police report lodged for abuse or misuse of a name and the government crest and logo. So here again is unexplainable gaps that we wish to highlight. With that, panel members, SUHAKAM officers, fellow observers, and interested members of the public, we submit very strongly that the evidence is clear that the state has failed to discharge their burden of proof. There were sensitive activities, there were prior threats and harassment. Very clearly, the couple has never been seen or heard from since the 30th of November 2016. And very clearly, there are huge gaps in PDRM's investigations. With that, my learned colleague will take over. Mr. Filippo will explain on the other part, which concerns the speeches that were made by PDRM.
Thank you, Ms. Audrey. It falls on me to just highlight a portion that evidence that was given before this panel in a way similar to the evidence that was also proffered in the first panel. This is found in D5 at page 27, paragraph 51 onwards. I will just highlight one or two salient points. This involved a branch of the PDRM, this special branch, and what we call religious policing. Both Joshua and Ruth disappearance need to be placed within a series of events that also led to the disappearances of Amri, Chitmat, and Raymond Coe.
Just 1 second. Mr. Filippo?
Yes.
It occurs to my mind, I think. We'll mark your, everybody written submission, will mark your written submission.
Sure thing.
Yeah, when we have a marking reference when we prepare the report. So this is yours, isn't it?
Yes,
Yeah.
it will be.
And this one as well. Yeah.
This is a bundle of authorities that we refer to in our submissions.
Shall we mark? Yeah. How shall we mark? Yours is as a family submission from the family.
It is on behalf of the, as observers, on behalf of the Sitepu family.
FWS, right? Family written submission.
Okay,
FWS. Yeah.
FWS. Much obliged.
Just one piece.
That's
yeah.
all. Yeah.
Yeah.
It's a very concise.
And this FWS bundle of authorities, yeah?
Yeah.
BOA. Right?
BOA,
Yeah,
bundle
BOA.
of authorities.
FWS BOA, yeah? FWS written submission. Okay, thank you.
Much obliged, Mr. Chairman. It is our submission that these disappearances arose from extra-legal and extrajudicial religious policing. In the light of the abolishment of the Internal Security Act, there are legislation, Prevention of Terrorism Act, POTA 2015, and SOSMA 2015 also. ASP Awaludin Jadid, whom we were acquainted with even during Operation Lalang's time, because he was a junior officer then who interviewed the then Hilmy Muhammad Noor. In fact, as a personal note, Mr. Chairman, I was concerned that when we heard about the disappearance of a certain Hilmy, I actually called my friend Hilmy and asked, are you around? He said, no, I'm not the gentleman. But it's interesting for us that the speech which has been ventilated and put before both panels highlighted the fact that this division of the PDRM expressed frustration and hindrance about the constraints they have in not being empowered by preventive detention without trial. It's important for me to highlight at paragraph 56 of our submission in page 29. On the 6th of November 2016, Awaludin delivered his speech. It was 40 minutes at a seminar at the KDN complex. The salient contents are the following. He claimed that the state is busy looking for terrorist group like the Islamic State. But he had forgotten the real enemies are groups like Bersih, Christian proselytizers, and Shia converts, paragraph 56.1 of my submission. And they are assisted by conspirators in the judiciary, the civil service, and even in JAKIM and the police. Perhaps the learned ASP was referring to his colleague Ayub Khan, who has a different viewpoint about the real threats to Malaysia. He bemoaned the loss of ISA. It was so much easier for the police to take action, he says. He claims that the new laws of POTA and SOSMA passed by our sovereign body called the Parliament were inadequate for their needs. Here, if I may respectfully say, a PDRM officer is crossing a boundary of commenting on the sovereign power of the people of Malaysia expressed through Parliament. He alleged that the Barisan Nasional, he even became political, a body that should be apolitical in investigation. That Barisan Nasional lost its 2/3 majority. Is a special branch there to protect a supermajority of a reigning government? Is it not there to protect the people of Malaysia? He claimed that after 2008, communities of faith were emboldened to make demands like using the istilah Allah. He further linked this to the sponsorship of so-called Christian proselytizers who prey upon vulnerable Muslim groups. May I make an aside comment that I failed to do so earlier? In the banking records of Joshua Hilmy, we saw how meager the sums of money are in the bank. These are from well-wishers, small gift offerings. There is no Christianization movement that funds an alleged huge proselytization movement that constitutes a threat. He pointed out that those involved were Padre Melayu, like Joshua Jamaluddin, Hilmy Muhammad Noor, who are now protected and hidden by churches. Again, a barefaced allegation that has no basis at all in law and fact. He ended by giving his opinion, the best way to deal with these enemies. He claimed that the Jabatan Agama Islam was powerless to act. His proposed way is not to use the laws of the land, which requires actual proof of violent intention. Quote unquote, kalau dia pegang saja pistol, kita akan tangkap. It was like a sense of regret that they could not find any instruments of violence or even evidence of any sort that is threat to public order or security. The way forward appears to be extra-legal. Quote unquote, his testimony. It is very simple. Orang putih cakap, it takes a thief to catch a thief. Maksudnya kalau kita nak tangkap pencuri, kita mesti menjadi pencuri. It's an extraordinary statement. Maybe we can say, perhaps it's a hyperbole in a speech, but should that words ever even be found in the lips of law enforcers to a young group of hearers, a new generation of our citizens? So after this speech, a number of events unfold, and this is where we commend similar fact evidence argument. On 18 November, on the eve of Bersih 5, police raided and detained Bersih Chairman Maria Chin Abdullah under SOSMA. On 24th November, Amri Chep Mat Awaluddin's E2 division admitted under the surveillance for allegedly Shiism was abducted on the street near his home in Kanga Perlis. On 30th November, the date, fateful date, which Joshua and his spouse, our client's family's sister, Ruth Sitepu, exited and never seen again. On 13 February 2017, Pastor Raymond Koh was abducted with visible CCTV testimony. It is our submission, learned members of the panel. These facts, this pattern supports what we call a similar fact evidence, which is found in paragraph 76 and page 37 of our submission, that the probative value of similarity, though may not be completely striking, but in this case, striking for our case, that the underlying link between previous incidences and current one, a nexus similarity establishing a system, facts supporting part of a same activity and similar surrounding circumstances. And what are their common features? One, it is involved in a religious situation. There were threats and harassments. There is a lackadaisical attitude in the police investigation. There is a cars involved. If there's a car, there is therefore a disappearing of a vehicle. We have also seen in the inquiry that the car of Pastor Joshua Hilmy was never to be seen again, and the car locks, or rather the renewal of road tax was never done ever again. And I may add, since we're on this point, on the immigration locks too, the couple was never seen to have exited the jurisdiction of this country. So it is the probative force and the similar facts that we are commending to this honorable panel to make the inference, an irresistible one, that Joshua and Ruth were abducted and deprived of their liberty, their body and their vehicle never to be found again. This involved logistics of more than one individual to disappear, an individual driving. We saw that in the Raymond Coast case, the multiple SUVs and men in balaclavas. We see this now, although we have no witness of a couple in a car also disappearing. Joshua and Ruth practice of their faith as an ethnic Malay and an Indonesian triggered a dark response of enforced disappearance. These are the common features. It cannot be merely dismissed as purely coincidental. It is apt to return to 1987 Operation Lalang, which I referred to just now, our Ludin's first foray into the state attempts to justify detention without trial. Honorable members of the panel, we are aware of the apex court decision of Minister of Home Affairs against Joshua Jamaluddin Othman, reported in 1989, where the federal court, led by a very learned jurist, Hashim Yopsani, made a very important ruling that conversion of individuals, be they ethnic Malay, by itself cannot be regarded as a threat to the security of the country. It also, the learned judge has held, offense against the freedom of religion and the practice of a religion accorded to all persons found in our jurisdiction. And the word is person, not just a citizen, because Ruth Sitepu, an Indonesian national, is accorded that federal constitutional protection too. Since I have the floor, I want to draw attention to a very important aspect of our submission. It is found in page 4T. The exited Malay convert family who came under the teachings of Pastor Joshua. It is an important component. I think this was given in a closed session, but it is permitted for us to highlight this here because the information has been redacted at the official websites. Learned members of the panel, there is a significant segment of testimony that has been disclosed to this panel, that a Malay couple with their family was converted and come under the teachings of the pastor. In a report that is found, and if you look at the footnote we give, and in that website, the Australian Immigration Administrative Appeals Tribunal, it's found the salient points where the reference to the letter Pastor C is actually Pastor Joshua Hilmy. The Immigration Authority Agency made the following findings: that the applicants are to be justified seeking religious asylum. They found that the testimony given was congruent to truth, that they could be arrested and prosecuted, punished by fines and canings and re-education and made to revert back to the Muslim faith. The fear of being physically harmed by radical extremists is found to have some validity. The tribunal is satisfied, and this is their decision, that the harms feared by the applicants include a threat to their life or liberty, significant physical harassment and ill treatment, and this is serious harm. They also found that given the existing country information and even the changes in the political circumstances, that pastors has been abducted, considered these abductions by unknown persons to be a significant and powerful indicators that it is dangerous to return this family back to Malaysia. And so both the family and the children were allowed to stay in Australia. This testimony confirms for us that the threats were not purely verbal, but an actual family that came under the teaching and help of this couple have to exit this country to save haven of a country that will provide them from these threats. I will pause here now and sit down before I make a final comment on the acquiescence point, and we'll show the video, and then later with permission a short concluding statement. Without, I will ask Mr. Cyrus to do in a very short submission about the investigation powers of the relevant authorities. Over to you, Mr. Tew.
Thank you, Mr. Philip. Good morning, Mr. Chairman, panel chairman, panel members and chairman. My submission is very simple, and I will keep it very, very short. Before I begin with my submission, the learned submission given by my Mr. Philip Koh and Miss Audrey earlier, I went through the evidence. Some of them are circumstantial, and I submit that all this, if put together, it will form enough to form a rope to tie the end of this case for this panel to decide on the case of enforced disappearance. If I may begin here, that my focus here will be on the duty and the investigative power of the police force in Malaysia, particularly in this case. We know as of a fact that our police force do have enough powers to conduct investigation, and they are very, very professional. In fact, they are the second largest force in the country for the national security. In this case, I refer to the written submission, page 31, that this case alone, there are 3 police reports that have been made. Number 1 is by Ram Elizabeth, Chembong report, as well as by Peter Permanent, as well as this by this Ketua Wira Perkasa is the Chembong report. It is noteworthy to note that the Chembong report by this Ketua Wira Perkasa against Joshua Hilmy was not investigated in a very thorough manner, if the panel is still remember on that. And when we questioned the investigating officer, Inspector Joe Fadley, it appears that he of the mind that it is not relevant at all. But in our case, this case have begun since Pastor Raymond Koh's case and Amri Chekmat. And the panel in SUHAKAM, in the earlier panel, have given the final decision. In the final decision itself, if I may digress is a little bit, in the final decision itself, there are points that the PDRM can and may investigate on, which is number 1, the Toyota Vios, the golden Toyota Vios PFC 1623, driven by this one Saiful Bahari, which also a special branch police officer. And this point alone is well enough for the PDRM to launch their investigation into this specific area. And this point was not investigated on. Similarly, on the Ketua Wira Perkasa, Chembong report was not relabeled on and investigated on. Further, my learned panel, in this case, on the Ketua Wira Perkasa, the police do have the power to utilize section 111 of the CPC. If I may just highlight a little bit of some of the powers. 111 of the CPC to require the attendance of the witnesses to come forward to give evidence of the case. But in this case, we never see this have been utilized in any other manner, as well as they can intercept and require documents from the public. But this was not, does not appear to be done in this case. Further, we also noted that there is no evidence to show that the police have taken off all the CCTV along the house of this Joshua Hilmy and Ruth Hilmy on the day of disappearance. And the matter have passed on for so long. Here I refer to briefly I refer to page 33. These are the list of some of the powers that the police do have: the power to investigate, the power to intercept, the power to search and seizure without warrant, the power to access computerized data. All these are some of the powers that the police do have, but we regret that this was not shown in the investigative powers by the 3 IOs. And here I would like to note that this case, the investigation of this disappearance was go through by 3 different IOs, and we were not told how the handover was done, whether the handover was done properly, and whether they were briefed properly by the previous IOs. And this is where it leads to my request at the end of the inquiry, where I have requested for the final time that the police not to show the investigating diary to us, but to the panel, for the panel viewing, to check and balance and see whether the testimony given by the police are corresponding with what stated in the investigating diary. And the investigating diary is a mandatory thing under section 119 of the CPC. And then I will end my submission here with a short submission on the diligent investigation, whether or not diligent investigation have been put in place. Here, as per the case of Said Muhammad Isa, there's a High Court revision case by Abdul Wahab Patayo, the learned judge at that point of time. And that case is talking about the diligent investigation for criminal matters. But here, we couldn't find, I couldn't find any cases on diligent investigation. That's the only case that I could find on diligent investigation. If we apply that to our case, I believe that it doesn't satisfy the test of diligent investigation. Further, as we look, there are clear evidence of harassment by text, phone calls, email, and even asked to leave the country. And that itself is telling. It has been more than 5 years that this case have gone on, and they have disappeared for more than 5 years. The police have more than enough time to investigate whatever that is necessary. And I will leave the, I'll pass on the time to Mr. Philip to do the closing and the final submission. Thank you, Ben.
Thank you, Mr. Sarasfu. May I ask? We will now bring before our honorable panel attention of two very short videos. It is relevant. The first video is Ibu Rosmawati Ginying, assistant-in-law of Ruth, wife to Imam Sitepu, who have instructed us. At a contrast event of a contrast complaints to Indonesian National Commission of Women, dated November 5th, 2021. The second video is Ram Elizabeth, dated 20th January 2021. That's it. Can you just repeat it one more time for us to?
Kami sangat kehilangan beliau. Dan kami berharap kepada seluruh kerajaan Malaysia juga dan seluruh saudara-saudara semua yang mengenal mohon bantuannya dan kepada Bapak Presiden Joko Widodo juga. Kami sangat berharap membantu keluarga kami Kak Ruth, karena kami sudah cukup merindukan, sudah bertahun-tahun tidak berjumpa dengan Kak Ruth. Kami sangat berharap Bapak mau membantu kami menemukan kakak kami. Tolong kami ya Pak Jokowi dan Bapak Menteri Malaysia, semuanya, seluruh yang mengetahui Kak Ruth dimanapun berada, bantulah kami, kasihanilah kami. Kami bukan orang berada yang bisa mengurus segalanya. Tolong kami, Bapak Ibu juga semua yang membantu kami dalam membuat Kak Ruth dan Bang Bos. Sudah sangat banyak terima kasih kepada keluarga di sana.
Okay, Ram Elizabeth, very short. This is.
Tak lupa juga mengucapkan banyak terima kasih kepada semua yang sudah banyak membantu mengusulkan kasus Kak Ruth ini. Kami tidak akan bisa membalas semua kebaikan Bapak dan Ibu. Tanpa Ibu, kami tidak bisa berbuat apa-apa. Dan juga kami minta tolong kepada kerajaan Malaysia, bantulah kami. Kasihanilah kami untuk bisa menemukan kakak kami ini. Semua kebaikan yang Bapak Ibu berikan, Tuhanlah yang akan memberi balasan kepada Ibu semua. Tolonglah Bapak Kerajaan Malaysia.
Members of the panel, the tears of these family members. In a working group of United Nations on this, the working group reports enforced and involuntary disappearances constitute the most comprehensive denial of human rights in our time, bringing boundless agony to the victims, ruinous consequences to families, socially and psychologically, and moral havoc to societies in which they occur. Paragraph 96 at page 47. The particularly egregious consequence of an enforced disappearance is a fact that as long as the fate and whereabouts of the victims are known, his or her loved ones are frozen in grief. We just witnessed that. The anguish in not knowing whether a loved one is dead or alive defies emotional comprehension. Ambiguity destroys the customary markers of life or death. So a person's distress is never validated. The community loses patience with the lack of closure and families becomes isolated. Ambiguity causes even the strongest people to question their view of the world, to question whether Malaysia is a fair, safe, and understandable place. The impact of this ambiguity on victims' loved ones have been recorded throughout the world. In one instance, which I cited, the Guatemala case, it seems to resonate in our case. Her brother's disappearance is not something that happened at a given time and place, but rather something that continues to happen inside her every time she comes close to that grief. For years, she dreamt of her brother's return. Members of the panel, I'm aware, I was a lawyer for Susanna, and they still dream of the return of Pastor Raymond Cole to the family. They clung to the idea that he was alive, but at the same time, he imagined he was suffering, and a conflicting wish he should no longer be alive. When a person dies naturally or due to an accident, there's a body, a social right that helps to accept the person is no longer there. But on the anniversary of a person's disappearance, and in the Guatemala case, the father said, I do not think that your brother will return. And then she felt that she had permission to leave the illusion behind, something that she had to do, and to continue to live. The witness stated it was very cruel and just and perverse. What relevance is this? We are not merely trying to make an emotional plea. The acquiescence of the state to this is part of the evidence accepted in international convention and practice. In Sir Nigel Rodley, Special Rapporteur, Commission of Human Rights on 3rd July report, he emphasized that these definition of disappearance, this intentional act that directly affects close family members, being fully aware they are hurling family members into a turmoil of uncertainty, fear, and anguish, and lying to the family. Acquiescence is part of these issues too. And the acquiescence add to this agony. You know, when I was reviewing the literature on this, a great writer, Michael Ignatieff, with some empathy to the security forces that enforce disappeared people throughout the Latin American country, Bosnia, Serbia, Croatia, Rwanda, he did observe the military and security establishment in some of those instances in truth and justice commissions were prepared to let the truth come out. But in our case, we were not even prepared. The tribunal that held that it was found to have been disappeared is dismissed in such peremptory terms by the then Prime Minister. And even as recent in Parliament, the Minister of Home Affairs just say that there are missing people under the penal code. Such callous dismissal. Even in Latin America, there was an acceptance of a truth of it. But of course, the refusal to allow responsibility to be fastened, clinging on tenaciously. Yes, elected governments that have chosen such commissions had to choose between the justice and their own survival at times, between prosecuting criminals or risking perhaps even a coup, or letting them go and allow the democratic tradition to take root. Chairman and panel, Joshua was born a Malay. Article 160 did define that a Malay is a person who professes the religion of Islam, habitually speaks the Malay language, conforms to the Malay custom. For Joshua, his birth was not something he could control, but his desire to exercise the freedom of conscience and belief has led to this traumatic, dramatic disappearance. When he embraced the Christian faith, he readily accepted he may not be construable by definition as a Malay, though very much an ethnic Malay. He no longer speaks habitually the Malay language, though he could, of course, do so. He no longer professes the religion of Islam. Ruth is not a Malay. She's an Indonesian. And as I say, that freedom was extended, is extended to such a person. I want to highlight a point. In the testimony, I did question the inspector. Are you more solicitous if there's a disappeared Western Caucasian? Is it because Ruth is just a mere Indonesian? He's treated like a migrant worker or a house help who decided to go missing, whereas this is not manifestly the case. Of course, the learned inspector refused to accept that. We also saw the refusal not to connect the Chembong report, which has virulent attack on the proselytizing activities of Joshua. He denies there's any connection. He didn't even pursue that angle. And even the angle of why the family of Joshua refused to have anything to do with inquiry or to assist in the investigation, to him it's normal. How normal can it be if a sibling of yours has disappeared from the face of the earth and you refuse even to cooperate? In Selangor, where Joshua resides, the non-Islamic religious control of propagation religion, we acknowledge under the federal constitution, the freedom to propagate is circumscribed by a proviso that state laws may provide for the control. We are lawyers here. We respect the rule of law. And I have drawn the attention to this learner panel that under Section 4, such an offense could result upon conviction and proof in a court of law, be liable for imprisonment for a term not exceeding 1 year or a fine not exceeding 10,000. Are the penalties too minimal for these impatient authorities? Yes, if Joshua has misconducted himself under the law, charge him, arrest him, produce him before the court of law. This is the quest of the family. Joshua's favorite segment of the Bible is the Sermon on the Mount. Among the many teachings of that great wise teacher, acknowledged in all the great faith, blessed are the persecuted. Joshua is among the blessed. Blessed are those who mourn. We have seen their relatives. They can't even mourn properly about the disappearance of their dear cut Ruth. I've mentioned that Joshua's name means deliverer. He has been delivered perhaps in a different sense. To his God, it is a strange glory. Ruth Sitepu Rutanga is a name that reminds us of a poignant and yet powerful narrative from the Bible. Ruth means a friend, a companion. She was a Moabite woman who decided to give up her roots to live as a companion to her single mother-in-law who have lost all the sons in their journey to seek relief from famine. And Ruth said to Naomi in these wonderful words, "Do not urge me to leave you, to turn back and not follow you." He addresses to Naomi. "For wherever you go, I will go. Wherever you lodge, I will lodge. Your people will be my people. Your God, my God. Where you die, I will die, and there I will be buried." Ruth made that pledge when he married Joshua, little knowing that that pledge may lead to her disappearance. Quis custodiet ipsos custodis. Juvenal wrote in the 1st century, "Who will guard the guards when custodians of law, as found by the first panel, can descend into the murky world of abduction, what repose and safety can us ordinary citizens and people who dwell in Malaysia seek? A former commissioner friend of mine who served in SUHAKAM acknowledged that when the Convention of International was commended to SUHAKAM to recommend to the government for signatory, the discussion went this way. I don't think we need that convention because such things do not happen in Malaysia. Learned panel members, it has happened. And we say that it has happened here. We urge that it must never happen again. We have made the recommendations. We don't want to repeat it. It's in the written. And with these remarks, we thank the panel for the gracious way of which, and the officers and my fellow observers too, in this whole journey we have taken together. And with permission, I will just make some concluding remarks at the end, merely to acknowledge further few short, very short points. Other than that, we rest our submissions. Thank you very much.
Thank you, Mr. Philip Ko, and all counsel for the family of Sitepu. I will now invite representative from PDRM to address the panel. PDRM's written submission will be marked as PDRM/WS.
Assalamualaikum warahmatullahi wabarakatuh, and a very good morning to our Yang Arif Datuk Sri, Datuk Tuan Ahli Panel Pesujaya SUHAKAM. Sorry, soal. Ya, tak dapat. Okay. Tinggi sangat. Dengan izin ya, Yang Arif, members of the panel, together with me today, I am Ahmad Zafir Mayusuf, Senior Assistant Commissioner with the Royal Malaysian Police, and assisting me today is DSP Muhammad Sabri, also from the Royal Malaysian Police, as the observer from the PDRM. Dengan izin Datuk Sri, Datuk dan Tuan Pesujaya SUHAKAM, izinkan saya untuk menyampaikan.
I'm sorry, Encik Zafir. Can we take a short 10 minutes break?
Sure.
Yeah. Okay. We will resume in 10 minutes.
Okay. Okay. Yang Arif, dengan izin, allow me to present my oral submission in our national language Bahasa Malaysia. Yang Arif, Datuk Seri, Datuk Tuan Sujaya SUHAKAM dan penggabungan pemerhati yang bijaksana. Pada hari ini 20 bulan Januari tahun 2022 telah ditetapkan bagi semua pihak untuk menyampaikan ucapan lisan seperti mana fakta-fakta yang terkandung di dalam ucapan bertulis yang telah dimajukan pada 17 Januari 2022. Sebagaimana kamar yang mulia ini sedia maklum, sepanjang pendengaran awam ini diadakan bermula pada 18 Februari tahun 2020 dan telah beberapa kali ditangguhkan akibat daripada penularan wabak COVID-19. Maka pada hari ini, selepas 22 bulan, seramai 26 saksi, iaitu 13 saksi orang awam, 7 saksi PDRM, 1 saksi pegawai SKMM ataupun Suruhanjaya Komunikasi Multimedia Malaysia, 1 saksi daripada Jabatan Immigration Malaysia, dan juga 4 orang saksi daripada Telco hadir untuk memberi keterangan di Dewan Yang Mulia ini. Dalam sesi pendengaran awam ini yang diadakan menurut peruntukan Seksyen 12 Akta Suruhanjaya Hak Asasi Malaysia 1999. Yang Arif, Datuk Seri, Datuk Tuan Sujaya yang lagi bijaksana, di dalam kes ini yang melibatkan kehilangan 2 orang, yakni pasangan Hilmy Hanim atau dikenali sebagai Joshua Hilmy dan pasangannya Ruth Sitepu atau yang dikenali sebagai Ruth Sitepu yang dikatakan telah hilang sejak 30 November 2016. Dalam kejadian ini, ada pihak-pihak yang mengaitkan kehilangan pasangan ini ataupun akibat daripada pekerjaan, fahaman dan aktiviti yang dilakukan oleh pasangan ini secara tidak langsung ada kaitannya dengan pihak berkuasa di negara ini. Yang Arif, Datuk Seri, Datuk Tuan Sujaya, ucapan lisan pada hari ini akan tertumpu kepada keterangan-keterangan dan dokumen-dokumen yang telah dikemukakan di hadapan panel pendengaran awam ini dengan menumpukan kepada 7 isu utama. Sebelum saya berhujah berkenaan 7 isu tersebut, izinkan saya untuk menyatakan bahawa kejadian atau tindakan enforced disappearance seperti mana yang dinyatakan oleh Peguam Pemerhati Mr. Philip Koh tadi tidak langsung timbul atau dapat dibuktikan sama sekali di sepanjang proses pendengaran ini. Walaupun isu ini tidak secara langsung dinyatakan di dalam mana-mana bahagian dengan izin di mana-mana in any part semasa pendengaran awam ini, namun semua pihak terlibat tahu akan tujuan asal sesi pendengaran awam ini, yakni adalah untuk mengenal pasti sama ada kehilangan ini adalah akibat daripada enforced disappearance. Seperti mana yang telah dinyatakan oleh saudara Simon daripada SUHAKAM yang menerangkan TOR bagi sesi pendengaran awam ini. Di bawah artikel 2, International Convention for Protection of All Persons from Enforced Disappearance. For the purpose of this convention, enforced disappearance is considered to be arrest, detention, dengan izin Yang Arif, abduction, or any form of deprivation of liberty by agents of the state or by persons or group of persons acting in authorization, support, or acquaintances of liberty, or by concealment of the fate or whereabouts of the disappeared persons, which place such a person outside the protection of the law. Yang Adik Datuk Seri Datuk Tuan Pusujaya, di dalam kejadian ini, satu laporan polis telah dibuat pada tarikh 6 Mac 2017 sebagaimana Sungaiwi Report 2249 Palang 17 yang telah ditandakan sebagai Exhibit 1. Satu kertas siasatan orang hilang ataupun OH juga telah dibuka. Siasatan yang telah dijalankan dan juga satu task force telah ditubuhkan oleh Ibu Pejabat Polis Daerah Petaling Jaya bagi mengesan dan menyiasat kes tersebut. Segala tindakan siasatan telah dilakukan bagi mengesan kehilangan pasangan ini. Pohon rujuk keterangan ASP Hairul Azhar bin Abdul Aziz IW13 pada 10 September 2020 muka surat 9 hingga 182. Juga keterangan ASP Fadli Zulfadli ataupun IW14 pada 17 September 2020 muka surat 7 hingga 153, 11 Januari 2021 muka surat 10 hingga 122. Dan juga pada 18 Ogos 2021 muka surat 15 hingga 93 dan 4 Oktober 2021 muka surat 8 hingga 75. Dan juga keterangan DSP Supari bin Muhammad IW15 pada 21 September 2020 muka surat 6 hingga 102. Semua kenyataan-kenyataan bagi ketiga-tiga saksi tersebut telah menerangkan secara jelas tindakan-tindakan yang telah diambil bagi menyiasat kehilangan Joshua Hilmy dan juga pasangannya. Ya Arif, ahli-ahli panel, izinkan saya untuk kembali membicarakan 7 isu utama yang terkandung di dalam kes ini. Yang pertama sekali, tiada keterangan penglibatan unsur jenayah dalam kehilangan Joshua Hilmy dan juga Ruth Sitepu. Kehilangan Joshua Hilmy dan Ruth Sitepu tidak melibatkan sebarang unsur jenayah. Ini dapat dilihat berdasarkan keterangan IW15 yang mana telah melawat rumah ataupun tempat kejadian, CCTV dan mendapatkan maklumat awal daripada jiran-jiran di sekitar taman Kampung Tengku. Pohon rujuk Note of Proceeding 21/9/2020 muka surat 15 perangan 13. Selain itu, Joshua Hilmy dan Ruth Sitepu pernah keluar daripada rumah selama tempoh 1 bulan dan 2 bulan atau tempoh yang lama dan duduk di tempat lain yang mana ia merupakan rutin bagi pasangan tersebut. Ini dapat dibuktikan dengan keterangan Grace Tanggamala, anak perempuan Peter Ponaman, IW2 di NOP bertarikh 18/2/2020, muka surat 70 perangan dan perangan 27, muka surat 70 perangan 27 dan keterangan Joshua Nandan Emmanuel anak lelaki Peter IW3 bertarikh 2/3/2020, muka surat 22 perangan 7 dan Susanti bin Basari IW10 NOP 1/9/2020, muka surat 114 perangan 2. Berkenaan dengan isu pertengkaran di dalam telefon yang disaksikan oleh Susanti bin Basari IW10 NOP 1/9/2020, muka surat 147 perangan 30 adalah sebagai permulaan kehilangan Joshua Hilmy dan Ruth Sitepu, telah disangkal bahawa perbualan tersebut adalah bersama rakan baik Joshua Hilmy bernama Munusami anak lelaki Arumugam Eksibit 126 adalah berkaitan yang mana keterangan telah diambil sebagaimana di dalam eksibit 129 iaitu keterangan Ananten anak lelaki Menusami iaitu anak kepada Menusami anak lelaki Arumugam. Isu kedua, punca kehilangan Joshua Hilmy dan Ruth Sitepu. Joshua Hilmy dan Ruth Sitepu di dalam keterangan-keterangan yang telah dinyatakan mempunyai masalah seperti mana ada pihak-pihak yang tidak menyukainya serta masalah di sekeliling iaitu kawan-kawan melalui Facebook seperti mana keterangan Juraima Joy Luit IW9 di dalam Notes of Proceeding bertarikh 1/9/2020 muka surat 31 perangan 10. Masalah ini dapat dibuktikan melalui keterangan rakan-rakan baik Joshua Hilmy dan juga Sitepu serta keluarga Ruth Sitepu bahawa Joshua Hilmy dan Ruth Sitepu pernah diugun. Namun Joshua Hilmy menyatakan tidak takut dengan ugutan tersebut seperti mana keterangan Iman Setiawan Sitepu IW7 Notes of Proceeding 4/3/2020 muka surat 119 perenggan 30. Masalah-masalah yang dihadapi oleh Joshua Hilmy dan Sitepu disokong dengan salinan email dan surat berjatakan logo kerajaan untuk mengusir Joshua Hilmy keluar dari Malaysia yang mana pelaku tersebut sanggup menyamar sebagai entiti kerajaan untuk menakutkan Joshua Hilmy atas faktor ketidakpuasan hati dengan fahaman dan ajaran yang dibawa oleh Joshua Hilmy seperti mana di dalam keterangan Selva Kumar Peace John Harris IW5 menyatakan keterangan tersebut lebih kepada perbincangan ajaran Jesus. Note of Proceeding 2/3/2020 muka surat 169 perangan 35 hingga 36 muka surat 170 perangan 3 hingga 13. Dokumen-dokumen yang dimiliki oleh Joshua Hilmy dan Sitepu yang melibatkan seseorang VVIP telah dibuktikan bahawa terdapat pihak-pihak yang tidak bertanggungjawab yang cuba memburukkan entiti kerajaan Malaysia dengan memasukkan dokumen yang mana dapat dibuktikan dengan eksibit 103A, eksibit 104 serta keterangan Iqbal Mirza bin Muhammad Jamaluddin IW16 di dalam Notes of Proceeding 5/1/2021 muka surat 94 perangan 9 dan keterangan Fazlina binti Amran IW18 Note of Proceeding 6/1/2021 muka surat 245 perangan 27 dan keterangan VVIP yang dinyatakan tersebut telah dirakam oleh ASP Zulfadli bin Yaakob IW14 Note of Proceeding 4/10/2021 muka surat 66 perenggan 1. Isu yang ketiga berkenaan dengan punca masalah-masalah yang dihadapi oleh Joshua Hilmy. Masalah yang dihadapi oleh Joshua Hilmy dan Ruth Sitepu berkemungkinan disebabkan oleh Joshua Hilmy tidak mengendahkan ajaran gereja seperti mana keterangan Selva Kumar Peace John Harris IW5 Note of Proceeding 2/3/2020 muka surat 172 perangan 7 atau penghinaan agama lain seperti mana keterangan Inspektor Nurul Huda bin Bustami IW12 rujukan Note of Proceeding 2/9/2021 muka surat 123 perangan 16. Masalah-masalah ini berpunca daripada tindakan perbuatan Joshua Hilmy sendiri yang menghina ajaran dan fahaman agama lain yang diamalkan oleh rakyat di Malaysia seperti mana peruntukan di bawah perkara 11 Perlembagaan Persekutuan iaitu kebebasan agama. Perbuatan Joshua Hilmy yang tidak mengendahkan ajaran gereja tetapi menghadiri aktiviti gereja yang berkemungkinan menimbulkan ketidakpuasan hati kepada pengamal agama gereja tersebut. Perkara ini telah membawa kegusaran kepada bahawa Joshua Hilmy membawa fahaman dan ajaran berlainan daripada gereja tersebut semasa aktiviti berkenaan. Sifat Selain itu, sifat taksub ke atas fahaman dan ajaran Joshua Hilmy yang tiada batasan yang membenarkan Joshua Hilmy menghina agama lain secara terbuka dengan menggunakan medium Facebook dan menyebabkan satu laporan polis yang dibuat terhadapnya bersabit cembung report 1417/14. Perbuatan ini menimbulkan ketidakpuasan hati kepada pengamal agama tersebut dan tersebut disebabkan perbuatan Joshua yang bertentangan dengan perlembagaan persekutuan. Yang keempat, bukti Joshua Hilmy dan Ruth Sitepu keluar daripada rumah dan meninggalkan negara ini. Keinginan Joshua Hilmy untuk keluar dari rumah serta membuat perancangan untuk meninggalkan Malaysia dapat dibuktikan melalui keterangan IW5 Sel Bakuma Peace John Harris yang menyatakan dengan jelas pada Disember 2015 bahawa NOP 3/3/2021 muka surat 6/24 hingga 26 adalah dirujuk. Yang kelima, pengetahuan Joshua Hilmy dan Ruth Sitepu mengikut jalan keluar yang tidak diwartakan. Pengetahuan Joshua Hilmy dan Ruth Sitepu untuk meninggalkan Malaysia dengan menggunakan jalan yang tidak diwartakan dapat dibuktikan melalui keterangan pegawai penguasa Immigration Puan Junaid binti Dalu Gamin IW21 dalam NOP 6/7/2021 muka surat 86 dengan 8 yang disokong melalui dokumen immigration di dalam Exhibit 114 serta melalui pengakuan Joshua Hilmy sendiri di dalam buku yang dikeluarkan oleh beliau bertajuk Sermon on the Mount di muka surat 19/7 di dalam exhibit seperti mana di dalam exhibit 6. Kebarangkalian untuk Joshua Hilmy menggunakan jalan tidak diwartakan untuk meninggalkan Malaysia adalah tinggi disebabkan Joshua Hilmy masih mempercayai ada pihak berkuasa sedang mencari beliau atas kesalahan yang dilakukan bersabit cembung report 1417/14 apabila ada menerima panggilan telefon daripada Inspektor Nurul Huda bin Bustamin IW12 seperti mana dari dalam Notes of Proceeding pada 2/9/2021 muka surat 123/16 dan disokong dengan keterangan Iman Setiawan Sitepu IW7 bahawa Joshua Hilmy mempunyai masalah pasport seperti mana di dalam NOP 4/3/2020 muka surat 150/6 serta keterangan Juraima Joy Luit IW9 yang menyatakan Joshua Hilmy dan Ruth Sitepu kerap diganggu oleh penguat kuasa. NOP 2/9/2021 muka surat 123/16 adalah dirujuk. Long Penguasa Puan Junaid binti Dalu Gamin IW21 mengesahkan jalan yang tidak diwartakan adalah merupakan jalan yang berisiko tinggi dan boleh menyebabkan kehilangan nyawa. Note of Proceeding pada 6/7/2021 muka surat 98/1 adalah berkaitan. Isu yang keenam, penerimaan keterangan dan dokumen daripada saksi awam boleh dipertikaikan. Keterangan dan dokumen yang telah diserahkan kepada pihak SUHAKAM daripada saksi-saksi awam boleh dipertikaikan disebabkan dokumen tersebut tidak diserahkan kepada pihak berkuasa yang berwajib, contohnya PDRM, untuk kesahihan dan analisa ketulingan dokumen tersebut. Ianya boleh menimbulkan spekulasi bahawa dokumen tersebut telah ditokok tambah atau diada-adakan serta terdapat perbincangan yang dilakukan bersama pihak lain sebelum ini. Pohon rujuk keterangan kontras NOP 1/9/2020 muka surat 25/23. Seperti mana dalam keterangan Juraima Lloyd IW9 yang menyebabkan salinan dokumen tersebut dimusnahkan. Di sini dilihat tindakan itu penyiasatan PDRM terhadap kes ini adalah terhalang. Akibat keterangan-keterangan yang mungkin dapat membantu dalam siasatan tidak diserahkan pada pihak berkuasa yang berwajib dan hanya timbul semasa sesi pendengaran awam ini. Yang ketujuh, keengganan kerjasama daripada saksi. Berdasarkan keterangan-keterangan yang telah diberikan oleh saksi-saksi awam, jelas menyatakan saksi-saksi ini sukar untuk memberi keterangan kepada pihak polis. Disebabkan saksi-saksi awam tersebut takut serta beranggapan terdapatnya penglibatan kerajaan dan campur tangan pihak tertentu yang meminta pihak SUHAKAM menjalankan siasatan dahulu seperti mana NOP 12/8/2020, muka surat 35, perenggan 9 dan muka surat 38, perenggan 7. Perbuatan ini jelas dilihat dengan penglibatan saksi-saksi awam ini hadir memberi keterangan kepada pihak SUHAKAM serta menyerahkan sebuah kotak yang berisi dokumen ke pihak SUHAKAM melalui peguam yang dilantik oleh keluarga Sitepu seperti mana di dalam eksibit 15 Notes of Proceeding 12/8/2020, muka surat 19, perenggan 1, muka surat 78, perenggan 1 sehingga 13, muka surat 79, perenggan 2 hingga 4 dan perenggan 8 hingga 9. Tindakan ini adalah bercanggah dengan peruntukan Seksyen 20(3) Akta Polis 1967 dan juga bahagian 5 bab 8 Kanun Tata Cara Jenayah Akta 593 yang mana memperuntukkan kuasa siasatan kepada PDRM. Kesimpulan, PDRM ingin menegaskan bahawa secara keseluruhan setelah fakta-fakta melalui keterangan saksi-saksi dan bukti-bukti yang telah diutarakan dan dikemukakan semasa sesi pendengaran siasatan awam ini, kes kehilangan Joshua, Hilmy dan Sitepu adalah satu kehilangan orang yang tiada kaitannya dengan kehilangan paksaan ataupun enforced disappearance seperti mana yang ditakrifkan di bawah artikel 2 International Convention for Protection of All Persons from Enforced Disappearance. Sepanjang pendengaran ini, tiada satu pun saksi-saksi maupun keterangan yang dibentangkan dapat membuktikan dengan jelas kejadian kehilangan ini diperlakukan oleh seseorang ataupun mana-mana pihak. Siasatan PDRM terhadap kehilangan kedua-dua mereka ini telah dan sedang berjalan sehingga ke hari ini. Siasatan kehilangan mereka masih belum selesai lagi. Menurut peruntukan Seksyen 101 Akta Keterangan 1950 telah menyatakan dengan izin, whoever desires a court to give judgment as to any legal rights or liability dependence on the existence of facts which he assert must prove that those facts exist. Perenggan 2, when a person is bound to prove the existence of any facts, it is said that the burden of proof lies on that person. Sehubungan dengan itu, di dalam pendengaran awam ini, tiada satu pihak jua dapat menyatakan, tak membuktikan secara jelas punca sebenar atau pihak-pihak yang bertanggungjawab atas kehilangan pasangan Joshua, Hilmy dan Ruth Sitepu. Prinsip keadilan berdasarkan keterangan dan bukti yang diperuntukkan di bawah Seksyen 101 Akta Keterangan 1950 perlu diamati dan dipenuhi sepenuhnya. Di dalam kes Yon Bank versus Hotel Flamingo and others 2005 1 MLJ 712 menyatakan dengan jelas bahawa dengan izin, burden of proof as contained in Section 101 Evidence Act 1950 is the burden of establishing a case, and this rests throughout the trial on the party who assert the affirmative of the issue. Tuduhan-tuduhan dan andaian-andaian liar untuk mengaitkan penglibatan mana-mana pihak berkuasa adalah tidak bertepatan sama sekali dan hendaklah ditolak sekeras-kerasnya kerana ia hanya akan menjejaskan imej dan kredibiliti agensi kerajaan berkenaan. Tindakan menuduh siasatan PDRM di dalam kes kehilangan tidak telus dan tidak kepatuhan pada Standard Operating Procedure SOP adalah tidak benar dan tidak berasas sama sekali dan semata-mata berniat jahat. Itu saja hujahan daripada pihak PDRM. Yang Arif, sekian, terima kasih.
Terima kasih Encik Zafir. Sekarang saya menjemput wakil daripada Bar Council. Dipersilakan.
Good morning, Honorable Commissioners. My name is Andrew Koo. I appear on behalf of the Bar Council's observer team. My co-counsel, Mr. Roger Chan, sends his regrets and apologies that he was unable to attend today because he is in court. And my other co-counsel, Ms. Chandra Ponadurai, is with us online. Perhaps Honorable Commissioners may first want to mark the submissions of the Bar Council Observer Team. They are in 2 volumes. One is the written submission itself, and then a second bundle is a small bundle of authorities.
The written submission will be marked as BC oblique WS, Bar Council oblique WS, BC for Bar Council. The bundle of authorities will be marked as BC oblique BOA. Yes, please proceed.
Much obliged, Chairman. I think a lot has already been said by Mr. Simon on behalf of the Human Rights Commission, my learned friends, the team representing the family of Ruth Sitepu. And I don't propose to go in depth into the submissions of the Bar Council. Just to say very briefly that it's really divided into 3 parts. One, we look at the whole question of enforced disappearance itself. And then secondly, we make observations about how the investigations were done. And then thirdly, we make some recommendations. So that's the gist of the Bar Council's submissions. Going to the first point, I think it's important, and my learned friend, Mr. Koh, has already tried to do that. But just to take a step back, perhaps, Honorable Commissioners, and to frame the context of this inquiry, or at least the circumstances giving rise to this inquiry. And I think the chronology, which is important, will be found in paragraph 20 of our submissions. And that is simply this, and if I may read it out. First of all, we have the talk by DCP Dato' Awaladdin Jadid, equating conversion out of Islam with terrorism. And this was made on the 6th of November, 2016. Then we have Amri Chitmat being forcibly abducted on the 24th of November, 2016. Then we have the disappearance of Pastor Joshua Hilmy and his wife, Ruth Sitepu, which is the basis of this inquiry, which occurred on the 30th of November, 2016. And then last in this chronology, we have the forcible abduction of Pastor Raymond Koh on the 13th of February, 2017. Now, the question before Honorable Commissioners, which is not an easy one, is whether or not the disappearance of Pastor Joshua Hilmy and Ruth Sitepu are part of this chronology. Or are they some distant outlier which has no connection whatsoever? I think that's one of the things that needs to be ascertained And I would agree with Senior Assistant Commissioner, we don't have a smoking gun, or perhaps in this case, a speeding car. We don't have that one critical evidence that will prove conclusively that there was a case of enforced disappearance, forcible abduction, intentional disappearance. But we may have to evaluate the different individual strands of evidence and then ask ourselves, is ultimately the sum of all these parts greater than the mere accumulation of the individual events? Is the sum greater than the whole? So this, I think, is the challenge for this panel of public inquiry, and it is your unenviable task to decide on that. What we do have are, as I said, strands perhaps of possible, Mr. Koh called it similar fact evidence, strands of interrelatedness or interconnection. So we have, for example, W16 and W18, the only two people who have a link between Raymond Koh on the one hand and Joshua Hilmy and his wife, Ruth, on the other. They were baptized by both, or if W18 insists, ritually bathed. She went quite at length, because she's a linguistics graduate, to try not to answer the question as to whether or not she was baptized. She went through this whole rigmarole of, well, it depends on the context and things like that. I think you all will remember that. But be that as it may, right? The question is, she and husband are the, in a sense, only link, actual link between Raymond Koh and Joshua Hilmy and Ruth Sitepu. And the question, I suppose, before the panel is, do you leave it at that? Or do you say, well, there ought to be more, there could have been more investigation? We don't know. We were, I think, a bit sidetracked by the whole issue of doctored photographs. And I would like to note that, although I will say something about that later, the police were very quick to knock down and to prove that the photographs were doctored. They seem to be very speedily activated to do that. And so the involvement of VVIPs, as SAC has said, kind of distracted us a little bit. But should there have been more investigation into the link? I suppose our conclusion is that there ought to have been, but there was none. And even if it was in reality all fake or all doctored, there is this thing called the law of unintended consequences, which in case that people seeing what they have seen on Facebook or elsewhere would perhaps have taken things into their own hands, to have done something in order to address what they perceived as a threat to VVIPs, or a threat to national safety and security, a threat to the position of Islam in this country because of the purported baptisms that were going on of people who were from a Muslim faith and a Malay background. So I think that's one strand of that, and these are highlighted in the Bar Council's submissions. I think the second thing I would like to go to is the way in which the investigations were done. And I think, sadly, I would have to characterize them by three lacks, not lacks in the Indian sense of 100,000, but three lackings, or three, what do you call this, deficiencies. One was the lack of urgency. Second was a lack of curiosity. And the third, consequent on the lack of urgency and the lack of curiosity, was the lack of results. Why do I say that there was a lack of urgency? We all know that the first police report was made on the 6th of March, 2017. Now, the police cannot be blamed for that. It comes to their attention by a police report that was made. The police report was made few months after the actual disappearance of Pastor Joshua Hilmy and Ruth Sitepu, simply because, some allowance was given to the fact that, at least in the past, they had gone away and had not come back for a while. But once news of Raymond Koh's disappearance had become a major feature, then people like Peter Pormanan, W1, was activated enough, and then his children, W2 and W3, were activated enough to sort of say, look, we need to bring this to the attention of the authorities. So we start where investigations are concerned with the 6th of March, 2017. And then it takes a month before W1 is called to give a statement. There is some evidence introduced to say that, well, it was quite difficult to get in touch of him. We called him and he didn't reply and things like that. But nonetheless, it took them a month. And then after interviewing W1, I think the police did write to the immigration department to ask for details of any movement. So they wrote, I think, if I'm not mistaken, on sometime in on 8th of April 2017. And they received a reply saying that there was no record. And then it was later realized that the reason there was no record was because there was a mistake, a transcription mistake of the IC number of Joshua Hilmy. Instead of 5037, it was 5307. And so when they keyed it in, nothing came up. I don't know when the police realized that mistake, but it took them until the 8th of October 2018. So a year and a half later, before they sent a second request with the correct IC number to ask for that same information. A year and a half. Secondly, we have the issue of statements being taken. Now remember, they disappeared on the 30th of November, 2016. Huzair bin Hanim's statement, who is the brother of Joshua Hilmy, his statement was taken on the 18th of December, 2017, more than a year after they had disappeared. Another brother, Firdaus bin Hanim, his statement was taken on the 19th of December, 2017. Ramram Elizabeth's statement, 28th of February, 2018. And then some of the other statements, Selva Kumar, Supramaniam, the neighbors of the house, October 2018, almost 2 years after the disappearance. So to try and classify this as a speedy investigation, I think would be doing injustice to the word speedy. And then, of course, as my learned friend, Ms. Audrey Pillai has said and reminded us, in terms of the two people who were in the house, who stayed in the same house as Joshua Hilmy and Ruth Sitepu, they were not interviewed until a week before they appeared before this honorable panel. 3 years later. 3 years. So imagine the criticalness, if there was any criticalness in timing as a result of the disappearance. Any advantage to be gained from that was absolutely lost through the delay. Even when the police eventually put out what I fondly refer to as an all-points bulletin, basically notifying all the different police stations all around Malaysia, Semenanjung and Sabah and Sarawak to look out for Joshua Hilmy and Ruth Sitepu. That was only done on the 14th of June, 2017. So even after the statement was taken on the 10th of April, it still took the police 3 months to issue this APB, all points bulletin, or I don't know what the Malaysian police term, I can't remember, but it's similar to that notification. And then one of the I think officers in charge of the police station said in his testimony that they had gone out and put up photographs of and distributed photographs of Joshua Hilmy and his wife Ruth Sitepu around the neighborhood, asking if people had any information as to whether or not they had seen that. And when were the flyers distributed? I think Inspector Zulfadi, I think, was the one who said that. When was the flyers distributed? December 2018. More than 2 years after the disappearance. I mean, I can understand some delay, and then you see flyers, but 2 years, people would have forgotten. Even if they did see something, even if they did recall. 2 years is quite a long time. So the question really is, I mean, we talk about the disappearance. Yes, there's one thing, and there's perhaps lack of evidence, as I said, lack of that smoking gun in inverted commas. But then you have to look from a institutional point of view. How do the police respond to a report of a missing person? Do they treat it with the same degree of importance, same degree of priority as they did trying to disabuse us of the fake photographs? I regretfully submit that I don't think so. It didn't have that same sense of priority. So Mr. Philip Koh talked about, did they not care because Ruth Sitepu was an Indonesian? I would put it further and say, did they not care because these were not VIPs? They were not important people. And so we just treated them like an ordinary missing person, if there is such a thing as an ordinary missing person. So there was a lack of urgency. Then there was a lack of curiosity. How many times did we hear the 7 PDRM witnesses come before us and say they didn't know about Raymond Koh? Raymond Koh hit the headlines on basically the 14th of February 2017 as this person who had been involved or allegedly involved with Malay community, possibly about helping with conversions, things like that. It was all over the news. And yet there were police officers, quite senior police officers, who basically came here and said they didn't know anything about it. It cannot be that it's only the special branch that keeps its ear on the ground and figures out some of these big picture issues and how it impacts upon a missing person inquiry. Once the police had known that Joshua Hilmy was perhaps involved in the same kind of activity as Raymond Koh, shouldn't alarm bells have started ringing in the minds of senior police officers and even the IOs? Would there be some connection? And that's why that chronology is important. Because if they realized that it was actually smack in the middle of this chain of events, it might have led to that urgency that was called for in this case. And then, of course, quite naturally, when there is that lack of urgency, when there's that lack of curiosity, what we have is a lack of results at the end of the day. We don't really have. And we can't say that just because we don't have the proof, therefore, it cannot be said that this is not a case of enforced disappearance, or it is. We don't know, but we might have been able to know about it if things had been done more speedily. And I would say that it's not just the police that need to be that need to be pointed out for this. Even at least one telco bears some responsibility. Because what did they do? This one particular telco, which I shall not name, right? When the police wrote to them, not once, but twice, for information about their phone records, the reply was, your request does not follow our format, so we cannot help you. Even though the police are writing to them, even though the police have said this is an important issue, all we get from the telco is, this does not follow our format. Please use this format. And do the police immediately rush and alter the request in order to fit the format? No. The first application is made on the 23rd of October 2018, again, almost 2 years after the couple had gone missing. 24th of October, the telco says, not complete, reject. The next attempt is 6 months later, on the 8th of April 2019, similar application. On the same day, the telco writes back and says, again, we reject, not complete. And finally, 2 months later, on the 24th of June, the police finally get it right, and then they get a reply. But by that time, the records that, are meaningless. There is nothing there. Imagine if this could have been done right from the start, right from very soon after the first information report was made on the 6th of March, 2017. I come now to the third point of, or the third part of the Bar Council's submissions, which is basically recommendations. I think we do need to have legislation that addresses enforced disappearance, because it has been seen to happen with respect to Pastor Raymond Koh and Amri Chekmat. It may happen here, we don't know, but at least if we had the law in place, at least we had some legislation that would guide us, then the authorities, be it police or other law enforcement agencies, would be able to stand guided by what are the elements of this crime, what to look for, what to investigate. At the moment, they appear to have nothing to go by. And so what we see is, sadly, very shoddy investigation, very poor transferring of information from one IO to the other, very poor communication between one OCS leaving and another OCS coming into his post. And we questioned the OCS whether there were standard procedures about when you take over the balai, is there a list of all the outstanding investigations? At least so that the OCS knows, even if it's not his primary or principal responsibility, because that still lies with the IO, at least he has that overview of some of the outstanding investigations that are connected to his balai that he will know of. But there's no such. So one of the recommendations is for these kinds of handover procedures to be made part of an SOP. So when IOs take over, when OCSs take over, they have a standard procedure which they can follow. So a law on enforced disappearance, some standard procedures about taking over files. It's not just a photograph of you handing over a nominal file for the photograph or the battle of authority, but actual briefings, actual handovers where you actually brief the incoming person about what is still open and outstanding. And then thirdly, monitoring and evaluation. And so the bar once again calls for a proper, for a professional, for proficient, independent police complaints and misconduct commission that will have oversight, independent oversight over the police force, so that weaknesses and complaints about the lack of urgency, the lack of curiosity, and the lack of results can be addressed to a specific organization or body constituted by the law of this country that will have the primary responsibility of investigating and looking into how investigations are done. So this is basically the overall gist of the submissions of the Bar Council. And all that it leaves me to do, Honorable Commissioners, is to thank you very, very much for your enormous patience over these last 22 months, I think it has been, with all the delays, all the things that have happened, and to thank the staff of the Malaysian Human Rights Commission for their sense of duty and sense of responsibility, for which the Bar is enormously grateful. Thank you, Honorable Commissioners.
Thank you, Mr. Koo. Lastly, I call upon the representative of Contrast to make written submission, oral submission. Please do so.
Hi, okay. So, Assalamualaikum warahmatullahi wabarakatuh. Good morning, honorable panel. First of all, we like to thank you for the time and opportunity given for us to deliver our submission orally. My name is Teoria Preti from Contrast Indonesia, one of the observers for the family of Ruth Sitepu. I will bring this submission in terms with my colleagues Shahar Banu and Fakhris. Our submission contains.
One moment, please. We'll mark your written submission. There will be contrast, yeah? Contrast oblique WS. Contrast oblique WS. That's a marking for your written submission. And now, please proceed.
Thank you very much, panel. We will begin our submission. Our submission consists of 5 sections based on the evidences and witnesses that we can access in our position in this inquiry. We will start with the background of the case, then the political context analysis, and then the legal analysis based on 3 elements of enforced disappearance stated in the International Convention. Then we have the conclusion, and lastly, the recommendation. So I will begin with Ruth Sitepu, is an Indonesian citizen who married Joshua Hilmy, a Malaysian citizen, in 2006 in Indonesia. And both of them work as Christian missionaries in Malaysia, who was last seen, both of them at on November 30th, 2016 by witness number 10, Susandi bin Bisari. At that time, they left their house in Kampung Tunku, Petaling Jaya in a hurry in their red Kancil car after they received a call from someone, a call which Joshua answered angrily, "Stop bothering me. I don't do that to you. Why are you harassing me?" And then it turned out that the harassing phone call is not the only intimidation and threats received by the Hilmys. Witness number 7, Iman Setiawan Sitepu, said there were 2 occasions where Joshua said that he was living under threat to his life. Was in 2009 during a conversation between him and Joshua when they met in Nambiki, Indonesia. The second was in 2015 when Joshua spoke to Bebas Bangun, his Batak adoptive father, over the phone. Since he married Ruth in Batak ethnic tradition manner, then Joshua gained an adoptive father of Batak ethnicity. So another occasion happened in May 2016 when Joshua showed witness number 5, Selva Kumar Peace John Harris, that he had received emails from Khairi Jamaluddin, who was the Minister for Youth and Sports in Malaysia back then. The correspondence mentions a couple's name whom Joshua baptized back on January 1st, 2015, and which Khairi said to Joshua, "It's better for you to leave the country." The witness saw that the first email from Khairi was official, as the email address include .gov.my and was carbon copied to the then Prime Minister, Mr. Najib. He said that in the email, Khairi asked that future email contact should be via a non-official email address. So consistent with that, also another witness, Juraima Joy Luade, heard from Ruth Sitepu that she and Joshua were ordered to refrain from performing baptism by Khairi Jamaluddin and Najib. In addition, she also heard from Ruth that she and Joshua received threats that they were going to be taken away. So we see that the disappearance of Joshua and Ruth, who work as Christian missionaries in Malaysia, should be viewed as related to the disappearance of Raymond Koh, Pastor Raymond Koh, and Amri Chemat, Shia religious leader, as will be explained in with my friends later. Meanwhile, the result of SUHAKAM inquiry for the disappearance case of Amri Chemat and Pastor Raymond Koh that was published on April 3rd, 2019, concluded that Amri Chemat and Pastor Raymond Koh were abducted by state agents, namely the Special Branch Bukit Aman, Kuala Lumpur. So from the political context analysis, we understand that Malaysia's constitution provides the right to profess, practice, and propagates one's religion, yet conversion of religion is restricted. Thus, there are Sharia law and state criminal law penalize the propagation of religious doctrines other than the doctrines and beliefs of the religion of Islam among persons professing the Islamic faith. Even though these laws related to religious conversion are inconsistent with international law and standards, but while these laws are still in effect nationally in Malaysia, we believe that all persons deserve to be treated equally before the law, as stated in Malaysia Constitution, and therefore all individuals have the right to a fair trial, including those who are allegedly accused of proselytizing to Muslims, which doesn't legitimize abusive arrest or enforce disappearance without legal proceeding. At the event seminar Belia Menentang Keganasan, a seminar which was opened by the Minister for Youth and Sports Khairi Jamaluddin on November 6, 2016, DCP Awaluddin Jadid, who was the Principal Assistant Director of Social Extremism Division Special Branch, PDRM, said in his speech, as derived from witness number 4 Ramanatan's testimony, his speech was about the association between the religious community that make Muslims apostates as terrorism and how it must be fought. Interestingly, we see that 18 days later, at November 24, 2016, Amri Chemat disappeared, who was a Shia religious leader. And then in November 30, 2016, Joshua and Ruth Sitepu disappeared, who were Christian ministers. And then lastly, in February 13, 2017, Pastor Raymond Koh disappeared, who was a Christian pastor. So in less than 4 months after the speech from this high-ranking officer in the Special Branch Unit of PDRM was made, it is recorded that there are at least 4 reports within 4 months, 4 reports of disappearance. We see there are 2 similar key findings between the 4 disappeared persons. Firstly, they openly professed their religions and were actively involved in social work while being so. Secondly, the timing of the victims' disappearances align with their activity background, which is related to apostate issues and happened around the time the Principal Assistant Director of Social Extremism Division made the public statement. Thus, the 2 similar key findings show that agents of the state, specifically in this case the Special Division of PDRM, is allegedly committed enforced disappearance under the claim of protecting the safety of the state from apostate issues that are considered as associated with terrorism. Mirroring in an actual practice, the state never gave explicit orders to abduct all these people. For as comparison, in enforced disappearance cases in Indonesia between 1997 to 1998, the commander of Jakarta Raya Military Regional Office made a public statement that they would secure groups that were deemed as posing a danger to the national stability and threatening the safety and security of the country. However, this act of securing resulted in the disappearance of 23 people, in which 9 of the victims were returned alive and were proven to have been kidnapped and tortured by the state's military at court. 1 victim later was found dead, and 13 others have yet to return, and their whereabouts remain unknown to this day. So even though the definition of terrorism as referred to Mr. Awaludin Jadid in his speech on November 6 is broadly stretched and very much deviated from unlawful acts that are considered as terrorism based on the 19 universal legal instruments against terrorism, we believe in the police and military holds a discipline where subordinates must follow their superior's order. Therefore, the definition of extremism that is considered as a threat to the nation and the state would have to be based on the orders that came directly from the upper chain of command and could not have been based on personal judgment of the officers individually. In his statement as witness number 17, Mr. Awaludin Jadid states that he was the Principal Assistant Director of the Social Extremism Division at Bukit Aman. He mentioned that the Social Extremism Division is an agency that monitors all levels from students, politicians, religious groups, NGOs, and every person who is considered as practicing and spreading extremist belief. And he viewed religious conversion as a type of extremism, and that extremism is a seed of terrorism and therefore needs anticipation. Consequently, it is clear that in case we believe there is a correlation between the activities within the Social Extremism Division in PDRM Bukit Aman and the disappearances of the victims who are viewed as spreading religious teachings other than Islam among predominantly Muslim community. Also, in relation to the ongoing inquiry, we have observed and noticed that during the inquiry, protection was not provided for all witnesses, with the reason being that there had not been any specific request for protection to the Royal Malaysia Police. So the fact that witness protection falls under the authority of the police, despite the fact that the alleged perpetrators are also from the police, becomes one of the causes for the lack of cooperation from the witness in exposing this case, which also affects Joshua Hilmy's siblings and members of his congregation giving their testimony in this public inquiry. They were afraid to provide testimony related to enforced disappearance of Joshua and Ruth, or when they had noticed that both Joshua and Ruth had gone missing. They were afraid to report it to the police, which is why the report was filed after 4 months of their disappearance, and therefore initial steps that could have been taken in early stage of disappearance were no longer possible. And further legal facts discovered throughout this public inquiry will be explained in by my colleague Fahris.
All right. Thank you, Capretti. Thank you all panels and SUHAKAM officers. I would like to read and explain about legal analysis. We concern about Article 2 of the International Convention for the Protection of All Persons from Enforced Disappearance that defines enforced disappearance as follows: the arrest, detention, abduction, or any other form of deprivation of liberty by agents of the state or by persons or groups of persons acting with the authorization, support, or acquiescence of the state, followed by a refusal to acknowledge the deprivation of liberty or by concealment of the fate or whereabouts of the disappeared person, which places such a person outside the protection of the law. Based on the definition by Article 2, we see 3 factors of enforced disappearance that must be highlighted. First, the act of depriving the liberty of one person or more. Second, such action is carried out by or with the authorization of the state. And the last, it is followed by a refusal to acknowledge the deprivation of said liberty. In regards to the disappearance of Ruth Sitepu and Joshua Hilmy, the elements of enforced disappearance are elaborated in the 3 parts. First, Part A, the arrest, detention, abduction, or any other form of deprivation of liberty. Unlike the abduction case of Raymond Koch and Amri Chemat that were recorded by CCTVs, the investigation process into the disappearance of Ruth Sitepu and Joshua Hilmy has yet to discover any CCTV recording or any witness who saw their car being surrounded by vehicles and a group of people wearing black masks. This matter has been repeatedly mentioned during the inquiry by the witness for PDRM, and it has become their basis for denying the disappearance of Ruth Sitepu and Joshua Hilmy as a criminal act. However, it must be noted that the CCTV recordings from Raymond Koch and Amri Chemat's cases were successfully gained due to their families' hard work and initiatives to visit the crime scenes. All the while, the police took years to act, and they did not follow up on important leads as provided in the statements by the witnesses in Ruth and Joshua's case, which is precisely what happened in Amri Chemat's case. Therefore, there is no basis for refusing to acknowledge that the disappearance of Ruth and Joshua is of a criminal nature. Next, the witness identified at least 4 occasions, as previously written on points numbers 3 until 6, where Ruth and Joshua Hilmy experienced intimidation and threats, either through phone call or emails, even to the extent of death threats on 2 occasions. First, in 2016, before Joshua Hilmy became uncontactable, witness Iman Sitepu mentioned that Joshua Hilmy made a phone call to Bebas Bangun. Bebas Bangun is Joshua's adoptive father by Batak custom. Bebas Bangun said, Bebas Bangun heard Joshua Hilmy made a phone call and said, they're going to kill us, sir. Another statement came from witness Susandi. He heard Joshua Hilmy speak angrily on the phone and said, "Stop bothering me. I don't do that to you. Why are you harassing me?" Ruth mentioned to witness number 9, Juraima, that she was banned from performing baptism by Mr. Khairi Jamaluddin and Prime Minister Mr. Najib Tun Razak. Therefore, Ruth and Joshua Hilmy's activity was put under close surveillance by state agents. It is fair to assume that both have been arrested or abducted by the same institution that is responsible for the abduction of 2 other victims, Raymond Koh and Amri Chemat, as their activity became the target, which is by openly professing their religion and were actively involved in social work while doing so. The institution referred to in this matter is as stated by the outcome of SUHAKAM's inquiry on Amri Chemat and Raymond Koh cases on April 3rd, 2019, which concluded that they were abducted by state agents, the Special Branch Kuala Lumpur. Ruth and Joshua Hilmy have yet to return and their whereabouts remain unknown. Next, part B, by agents of the state or by persons or groups of persons acting with the authorization, support, or acquiescence of the state. Based on the aforementioned chronology of this case, we discover patterns that show the state's involvement in the disappearance of Ruth and Joshua Hilmy. Here are the patterns of the state's involvement as previously mentioned. First, based on SUHAKAM search as well as witness Awaluddin Jadid's statement, the police has a special division whose duty is to address social extremism in religions, specifically to combat teachings viewed as heretic or disrupting to Islam as the majority in Malaysia. The speech of DCP Awaluddin contains claims of protecting Malaysia Muslims from apostate issues that are considered associated with terrorism, arresting people who are viewed as troublesome, and tracing these people in order to fight back. As written in the statement of witness Ramanathan, the second similarity between the 4 disappeared persons, Ruth Sitepu, Joshua, Raymond Koh, Amri Chemat, lies in the time of the disappearance of the victims that aligns with the apostate issues reasoning, and it happened around the time of the speech given by the Principal Assistant Director of the Social Extremism Division. Then threats addressed to Joshua Hilmy through email sent from an address ending with .gov.my by Minister for Youth and Sports, Mr. Khairi Jamaluddin, that is carbon copy to Prime Minister Najib Tun Razak. The emails were shown to witness number 3, Josiah Nandan Immanuel, and witness Salva Kumar Peace John Harris. According to witness Juraima's statement, Mr. Khairi Jamaluddin and Najib Tun Razak ordered to Ruth to stop performing baptism. In addition, in their statements, the witness expressed their fear of giving testimony or reporting Ruth and Joshua's disappearance, as well as their reluctance to get involved in Ruth and Joshua's activity in any way due to the big names involved. Such statement came from witness Juraima and witness Susandi. In regards to the disappearance of both, the witness from PDRM who were present throughout the public inquiry show the sluggishness and passivity of the law enforcement officers in looking for clues or even to follow up on existing leads. However, it is interesting that according to witness number 12, Inspector Nurul Huda bin Bustami's statement, who was the investigation officer in a sedition law case in 2014, where Joshua Hilmy was the reported party, show how the police were actually able to be more proactive in searching and tracking Joshua Hilmy's whereabouts compared when Joshua Hilmy has become the victim of enforced disappearance. The witness hand a request to look into Joshua Hilmy Facebook account to cyber GSGK Bukit Aman and SKMM Putrajaya. From it, he managed to acquire Joshua license plate. And after the witness submitted to a request to JPJ, the witness then gained the name and address of the license plate owner. The witness also made a visit to that address and asked around the neighborhood. The witness also traced Joshua's phone number, the address, and the phone number. The police assertiveness in the sedition law case in contrast to their positivity in dealing with the disappearance cases, which shows that they deliberately did not perform to their best ability in finding them both. Lastly, although SAC Fazil didn't testify in the public inquiry of Ruth Sitepu and Joshua Hilmy, yet another similar pattern from Raymond Koch and Amri Cemat cases occur. Therefore, the importance of SAC Fazil's statement in shedding light on the enforced disappearance of Ruth and Joshua will be explained in the submission. During the inquiry for Raymond Koch, the head of the Ops Jejak Paderi Task Force, SAC Fazil, and the IO in Raymond Koch case, ASP Supari, told that the inquiry CP Huzir in Bukit Aman coordinated and directed the investigation of the three cases that Amri, Raymond, Joshua, and Ruth Sitepu, despite his denials. We believe it is not a mere coincidence that the same directs all three cases with similar patterns in Bukit Aman, and all three investigations are carried out with minimum efforts to provide minimum results as well. The last part is the part C, followed by a refusal to acknowledge the deprivation of liberty or by concealment of the fate or whereabouts of the disappeared person, which places such a person outside the protection of the law. Regarding the disappearance of Joshua and Ruth, we consider the law enforcement to have performed very minimally when working the case. Some state institutions even show a tendency to deny any knowledge of the act of the deprivation of liberty over Joshua and Ruth Sitepu. Supporting reasons for the denial by the state on Joshua and Ruth Sitepu cases provided by the witness in the public inquiry are as follows. First, Chief of Police ASP Shafi'i instructed witness number 20 Ahmad Sibe to trace the license plate and recent address of Joshua and Ruth Sitepu, but Ahmad Sibe did not provide him with any information about it. Next, the immigration office does not have any record showing activity of entering from leaving any country on Joshua and Ruth Sitepu passports in their system. They just know about get in and get out. The third, the intention to investigate this case in a serious manner has not been shown. One occasion is that Sergeant Sibe failed to trace the license plate and phone number of Ruth Sitepu and Joshua. Other than that, when the investigation was transferred to another officer, namely Hairul Azhar and the SP Omar, they failed to retrieve any information from Sergeant Sibe when many parts of his investigation result were questionable. The investigators also did not figure out the nature of Ruth and Joshua activity. A member of the police, which is witness number 15, the SP Supari, who assisted Sergeant Sibe's investigation, did not discover passports and relevant documents and therefore the disappearance of Joshua and Ruth wasn't of criminal nature, according to DSP Supari. This different from Pastor Raymond Koh. As the previously explained, elements are met that Ruth Sitepu and Joshua Hilmy are outside the protection of the law. They are in a state of being without the presence of a lawyer, family, and even without access to health care or guarantee of being free of torture and or other inhuman treatments. Consequently, the looking for both of them, Raymond, Ruth, and Joshua, must continue as soon as possible. The conclusion in this submission will explain from my colleague, Shaharbanu.
Thank you, Fakhris. I will further the conclusion. The element of enforced disappearances are present in the missing of Ruth Sitepu and Joshua Hilmy, related to the pattern of two previous cases investigated by SUHAKAM. The four disappeared persons share two cases of similarity. Firstly, they openly profess their religion and were actively involved in social work while doing so. Secondly, the timeline of the disappearances of all victims fits their activity background being related to the apostate issue. Also, the event happened around the time when Principal Assistant Director E2 or Social Extremism Division, Special Branch PDRM Bukit Aman was made. By meeting all three elements of enforced disappearances, it is therefore fair to assume that Ruth Sitepu and Joshua Hilmy have fallen victim to arrest or abduction by the same institution that is alleged responsible for the kidnapping of Pastor Raymond Koh and Amri Shemep, with the target being the victim background activity. In this matter, the institution previously referred to our state agent, namely the Special Branch Bukit Aman, Kuala Lumpur. The absence of protection for witness become one of the factors for the lack of cooperation from the witness in providing testimonies that can help uncover the enforced disappearances of Ruth Sitepu and Joshua Hilmy. However, as long as the authority to provide protection for the witness in case where the alleged perpetrator are also part of the police under the police, then such a dilemma will keep recurring in the future and will not induce a process that might bring justice to the victim and the families they left behind. And this will be our last part. I will read the recommendation of submission on Joshua Hilmy and Ruth Sitepu enforced disappearances case. And the substance of the International Convention for the Protection of All Persons from Enforced Disappearances, also called ICPPED, contain general principles of international law which are mentioned in the United Nations Charter. They are refrain from the threat and use of force and respect for human rights. Theoretically, the principles of international law are force and respect for human rights. Theoretically, the principles of international law are one of the primary sources of law, which should be obligated by all of the states, including Malaysia. Enforced disappearances, the prohibition of which a peremptory norm or jus cogens represent a grave threat to life. In this case, Malaysia is likely to be found to have violated of duty to protect life as well as other rights, such as prohibition of torture or other inhuman treatment or punishment, the rights to liberty and security of person, and the right to recognition as a person before the law. In human rights law, the state has to respect, protect, and fulfill the human right of every person in it. If the state has violated human rights, then the state should be responsible for carrying out full reparation, namely revealing the truth and restoring the rights of victims and their families. Internationally, state responsibility is a customary international law as codified through Article on the Responsibility of States for International Wrongful Act or ERSIWA. And in this case, Malaysia should be responsible for revealing the truth about disappearances of Ruth Sitepu and Joshua Hilmy. Also, Malaysia should restore the rights of Ruth Sitepu, Joshua Hilmy, and their families. Based on explanation above, that enforced disappearances is a use cogence, the states, which is Malaysia, has been enforced disappearances to Ruth Sitepu and Joshua Hilmy. However, Malaysia did not ratify the International Convention for the Protection of All Persons from Enforced Disappearances. Malaysia still has responsibility for revealing the truth of the enforced disappearances of Ruth Sitepu and Joshua Hilmy and restoring the rights of Ruth Sitepu, Joshua Hilmy, and their families. Lastly, the government of Malaysia is urged to establish a committee for witness protection and victims who are independent and might execute their authority independently. By doing so, the state can be present, protect, and guarantee the work of searching for truth on cases where state agent may be involved, including when the alleged suspect is law enforcement officer. This submission is prepared by the Commission for Disappeared and Victim of Violence Contrast Indonesia on behalf of Ruth Sitepu family in Indonesia. Thank you.
Thank you, representative of Contrast, for your oral submissions. Yes, Mr. Philip, you have something to say?
Chairman, it falls on me to make some concluding remarks, and it is not in relationship to anything that they said all by my learned friends. So it's not a reply. Mr. Chairman, in my remarks earlier or submission, I did not touch on the recommendations clearly. I would like to draw attention in the bundle of authorities that we have included the award of Datuk Ma with learned commissioners, Professor Aisha and Professor Nick Salida. It is important to draw our attention to that because the recommendation is wholly also something we commend to this learned panel. Essentially, at page 78, at paragraph 173, the recommendation of the then panel is that authorities ought to respect freedom of religion as a fundamental human right. In the Universal Declaration of Human Rights, also through our Article 11 of Federal Constitution, and additionally, there is a reference to International Covenant of Civil and Political Rights, the Declaration of Elimination of all forms of intolerance and discrimination based on religion, belief, or resolutions of Human Rights Council and General Assembly. Mr. Chairman and the learned members, when our beloved nation was launched in independence in 1957, the founding father, Tunku Abdul Rahman, in the proclamation of Merdeka, said that Malaysia will join with the international community of nations, ever in search of the happiness of the peoples of Malaysia, adhering to the principles of justice. We commend the recommendation of Datuk Ma and his panel that there should be a demarcation between the PDRM and religious authorities rather than they working in such a manner. We recognize that in instances there could be a threat to public order, the police could be involved, but not in the manner of which we have seen in similar fact evidence of Raymond Koh's case and Amri. We also adopt fully the recommendation of the standard operation procedures of the police ought to be looked into, of the IP papers, and the distinction between merely classifying these cases as missing persons. It ought to have that demarcation. In evidence that has come to some proximity and probability, the police ought to classify this as enforced disappearance or serious abduction cases. So Chairman, it results on me now to acknowledge with thankfulness to the Almighty and also to the staff of SUHAKAM, which has rendered every professional and objective help, and to my learned friends from the PDRM, who has done their duty according to their convictions. And of course, my learned friends from the bar. I must record here my gratitude to my young colleagues here, Ms. Audrey Pillay and Ms. Sarah Stew, who out of their own personal commitment has given what they believe is their share of the duty. With those remarks, we draw our submissions to the close and once again acknowledge with gratitude your panel too, who has listened patiently and has dispassionately queried us also and challenged us as you challenge all observers and witnesses. With those remarks, we thank you for the patience and we await the issuance of your decision in the near future. Thank you very much.
Thank you, Mr. Philippo, and once again, thank you to all observers, representative of observers, for your respective oral submissions today. We will endeavor to come up with our decision and report as soon as possible. Encik Simon, have you got anything to add before we adjourn?
No, that is right.
Thank you. Together with the chairman and other panel members, big thank you for the patience. I think in SUHAKAM's experience, we never had such a long inquiry of 22 months. I think all of us should be applauded for the commitment. It's a painful decision, and I think we acknowledge the pain of the family. I think no one wants anyone disappeared. So I think it's in that spirit, we will look at all evidence and all submission, and we will do our best. And I think Dato' Sri, in his opening speech in the last panel, also said that we were trying to complete everything before we leave, our term comes to an end. Thank you.
Okay. Thank you very much, Dato' Sri. I would like to take this opportunity to thank all who are present here today. We are here to find justice. I mean, coming from a different background, listening to the presentation, man, especially the oral presentation today, this is really something that I am really looking forward to after 22 months sitting in a chair. Patiently, the word patience was never part of my vocabulary, but today I learned what patience means. And then I listen with, what do you call it, with an open mind, like many of my colleagues here. And we will deliberate, and given the documents that we have here, this is really something. So thank you very much, especially to our secretariat here, Simon. You know, I can see Faiz there. They have done a wonderful job here. Thank you very much.
From the chair, also thank you to our secretariat. The secretary will inform parties of the date, as soon as possible, when we are ready with the report. And with that remark, the session for today comes to a close.